Hey, welcome everyone. I think we're going to get started because we have a lot of material to cover here. I'm Cam Hoang. I'm joined by my colleagues Tim Hearn and Kimberley Anderson, as well as our two guest speakers today. With us we have Luke Komarek, who is Senior Vice President, General Counsel, and Corporate Secretary at Christopher & Banks Corporation. Prior to joining Christopher & Banks, Luke was a General Counsel for several public and private companies in the medical device, semiconductor, and office imaging supply businesses. And we also have with us Alyn Bedford from U.S. Bank. So prior to joining U.S. Bank, Alyn was practicing at Faegre, and before that, she clerked on the 8th Circuit with the Honorable Diana E. Murphy. So welcome, Luke and Alyn. We're here to talk to you about preparing for the 2017 proxy season. So turning to the agenda, we are going to run very quickly through some highlights of things that you do need to know for the 2017 season. And then we'll be spending a little bit more time talking in depth about virtual and hybrid meetings, shareholder proposal developments, proxy access. And then we'd like to turn to Luke and Alyn and get their perspective on their priorities for the 2017 season. And then if all goes well, we'll close with some salient points for 10K disclosure. So now I'd like to turn it over to Tim to tell us about say-on frequency.
Thank you, Cam. This is just a reminder slide. The first say-on frequency votes were taken, most companies took them in 2011, and they need to be taken every 6 years. So it's coming up next year, 2017. You'll need to include a say-on frequency vote in your proxy statement. Just to remind you, the vote that's taken needs to give shareholders a choice of whether the frequency will be every 1, 2, or 3 years for the say-on-pay vote. The disclosure that you put around that is that you'd say the vote, the say-on-frequency vote is non-binding. It's an advisory vote. You disclose the current frequency of the votes that are taken, what was decided last time, and when the next say-on-frequency vote would occur. And also one other note, smaller reporting companies were allowed not to do their first vote until 2013. So if you were a smaller reporting company in 2011, you have until 2019 to hold your next say-on-frequency vote. That's all I'm going to say on this slide. I think we go to Kim now on Golden Leash.
So there was NASDAQ made some recent changes to its rules. And effectively, what needs to be now disclosed by NASDAQ companies are any agreements or arrangements with third parties to pay a director or director nominee, generally with respect to a proxy fight. So what would typically happen is that you have in a typical arrangement, a director or the nominee is going to be entitled to receive compensation if the activist in the company for which they are acting achieves certain performance levels or over a specific period of time. For example, if the goal is that someone achieve a specific stock price, there would be additional compensation paid if the issuer manages to help achieve these, or if the company achieves these goals. So really what it comes down to is that the disclosure has to be made in a proxy statement no later than the date they file their proxy statement in connection with its next meeting in which directors are elected. And this would continue until at least 1 year after the time that the agreement remains in place. There are exceptions to this if it's simply a matter of reimbursing expenses or otherwise. For many companies, this will not be relevant. However, if there was a proxy contest or you do have directors that have outside arrangements, it is something you want to take a look at. And you may want to amend your D&O questionnaire to specifically ask this question to ensure that you have all the relevant information. So I'm going to turn it over to Cam to discuss proxy, the ISS voting policies.
Thanks, Kim. So this is the year when ISS's updated overboarding policies will go into effect. So CEOs of public companies may not sit on boards of more than 2 public companies besides their own. For other directors, a negative recommendation comes into effect if they're sitting on more than 5 public company boards. And in addition to ISS, of course, it's always worth it to pay attention to what your investors' policies are as well. So for example, for BlackRock, the limit is actually 4 boards, it's not 5 boards. For companies that are planning on adopting non-employee director compensation plans this year, it's worth noting that ISS is going to be looking at certain qualitative factors in considering these plans, especially if they make the SVT analysis and it turns out that the plan is costly. For companies that are considering adopting general equity compensation plans, there are additional provisions on when dividends may be paid on stock awards and also minimum vesting requirements on those stock awards that really you should be paying attention to because they will be factored into the equity plan scorecard this year. And then it's worth noting there are certain practices that ISS would consider problematic and that would lead to recommendations against your directors, not just on a one-off basis, but on a year-to-year basis. And so any restrictions on shareholder amendments to bylaws, ISS will be taking a close look at. And what we're talking about are restrictions that include, but are not limited to, prohibiting the submission of binding shareholder proposals or ownership or holding requirements on such proposals that exceed what's required in the SEC's Rule 14A8. For companies that are considering an IPO in the year, if the company has adopted bylaw or charter provisions that are materially adverse to shareholder rights, that's another area where ISS may very well end up making recommendations against your directors. And so I'd like to turn to Luke and ask you for your perspective on engaging with ISS on their voting policies.
By way of background, Christopher Banks is a fairly small capitalized company, so both ISS and Glass Lewis have a fairly significant influence on the vote, depending upon the recommendations. And so, our experience has been kind of interesting. We haven't had a negative recommendation from ISS for a couple of years, but or for several years actually. But last year, in reviewing our proxy, where we had a significant turnover in the board, we had an activist come out of the woodwork, for lack of a better term, in March of 2015. And in March of 2016, we reached a settlement agreement whereby 6 members of our board went off and 4 new members came on. And as a result of that, we didn't have, when we published the proxy, we didn't have anyone on the nominating and governance committee standing for re-election. So initially, ISS came out and said they recommended a vote against our CEO because we didn't have a nominating governance committee. Clearly, they didn't read the proxy. We talked about how we had 6 meetings in the fiscal year, and so we ended up contacting them, and as a subscriber, I was able to get the attention of the client person, and they immediately corrected it. And they went on to note that upon further review, the company does have a formal governance and nominating committee, which is comprised of independent directors and held 6 meetings during the year, as discussed in the proxy. However, none of the existing members of such committee are standing for re-election. And then, while the company has not yet disclosed the members of such committee going forward, it does not lack a formal nominating committee. So, interesting development. If you have a committee where none of the members are standing for re-election, you might want to just, indicate in your proxy you are in fact going to have that committee going forward. I do know also that, and I assume many of you do this the same, you do need to check their data that they use to do the quick score. I think that period is about to expire, or just recently expired, but they do make errors when they go through your SEC filing, so it's very important to go through and correct that information for them, because it doesn't impact your quick score, which also can impact how they view you in a variety of areas. So.
Thanks, Luke. And especially for smaller public companies where you're not getting a chance to review the voting recommendations before they come out, I think it's really important just to review the report as it comes out and quickly get back to ISS if there's something that needs to be fixed, because otherwise it could create issues with your vote. Just some other ISS developments I want to point out. Their pay-for-performance methodology was updated, where in addition to TSR, they're now going to be providing an analysis on return on equity, return on assets, return on invested capital, certain other financial measurements. This is strictly for information only at this point. They're still focused on TSR for their pay-for-performance analysis. And Quick Score has been rebranded to Quality Score for this year. I think the methodology underlying that is still very much the same, even though they have added a number of criteria that people might need to focus on.
I do note that one commentator has suggested that in the CDNA, you discuss all 6 of the financial performance measures, even if you don't use them. I don't know whether we will be doing that yet with respect to our proxy. We do fiscal, earnings or financial highlights. So, but I think that is something to consider whether or not to address those factors, whether or not you actually use them in your compensation program. So,
Oh, good point. Let's turn to Kimberley for a Glass-Lewis update.
So there's not a whole lot to discuss on Glass-Lewis. Nothing very extraordinary here. However, one point, as Luke noted, they have the issuer data report program. So there is, it's currently open enrollment. It allows you to sign up and get their, essentially their report that goes through the corporate governance factors. It's first come, first served. There's a limited number of spaces based on each market. So don't assume you actually have until January 6th to sign up if you have not done so already. One thing to keep in mind is that they're very clear that they're only going to give you about 24 or 48 hours to look at the report because they have a lot of things to do. And if that happens over a weekend, then you'll be working that weekend because they're not going to give you much time, and sometimes it's as short as 24 hours. But that does allow you to look at some of these things in advance and help catch errors. So one of the differences on Glass-Lewis with respect to overboarding is particularly with respect to executives. So if you're an executive at ISS, you can be on your own board and 2 others. On Glass-Lewis, it's an executive of not more than 2. So if you're on your own, then it's 1 more. So it's a tighter threshold. Now, Luke, have you had any experience or concerns with respect to some of these overboarding issues? And have you ever worked with Glass-Lewis on these?
we haven't worked with Glass-Lewis, but we did have a overboarding experience about 5 or 6 years ago. And both ISS and Glass-Lewis recommended against both the overboarded member who was a sitting CEO of a public company and at that point in time was on our board, his board, and 2 others. And the vote was extremely close as a result, notwithstanding the fact that we, as part of the proxy, we had filed a commitment, an addendum to the proxy to the effect that the board member was going to address that issue and go off a board by the end of that calendar year. And we ended up interacting with our shareholders directly as opposed to Glass-Lewis and ISS. But we were able to convince a number of shareholders to switch their votes. But it was such that in one instance, one of our, I think our largest institutional shareholder switched the vote with respect to the overboarded director, but did not switch the vote with respect to the chair of the Nom/Gov committee. And so that individual barely got elected by we had a plurality at the time, but the number of votes in favor was just barely over 50% in her favor. So in our instance, as I said earlier, Glass-Lewis and ISS recommendations can make a big difference in what the vote totals are going to be.
And Luke, I think you had observed that often their recommendations don't really square with how board or management would feel about the relative strengths of the directors, right?
True. And I think it's important that both ISS and Glass-Lewis's recommendations, from my perspective, if a individual is an executive at a company is overboarded, the company that should be most concerned about it is where they're an executive. But ISS and Glass-Lewis don't vote against the individual being elected as a board member at that company. They take the position if you're being paid as an executive, presumably that's where you're going to devote all your services. But so I think that's the interesting perspective that they take on that. So.
And Alyn, have you ever had any issues or concerns with respect to overboarding or with respect to, or are you really even that concerned with Glass-Lewis since you guys have so much direct contact with your major shareholders?
Yeah, I don't think Glass-Lewis doesn't control that much of our vote. Our proxy solicitor pegs it at about 3 or 4%, but we obviously pay attention to both Glass-Lewis and ISS. And actually, we spoke to Glass-Lewis recently. They're doing, they seem to, have this whole big new outreach effort. They have this IDR program they launched, and they've also, starting to invite people to engage. We had not engaged with them previously, but we did this year. And this specific issue came up. We have 2 of our directors who are CEOs and are on our board, plus another in addition to their home board. So this will, this will be an issue for us this year. And some insight they shared with us on the phone was that things that might mitigate their concerns, if you can disclose these things, are location of the various board and executive responsibilities, detailed attendance disclosure, and a lot of detail about your board evaluation practices. So I'm not quite sure what we're going to do with all of those and what changes we will or won't make, but just, those are considerations if it's a concern.
So one question with respect to things like location of
Yeah,
director
right.
service, is it a concern about travel time? I was
the
curious
sense.
about that.
Yeah, that was the sense. And we hadn't called them to engage on this issue, so I think it was just very conversational. I don't know that we maybe asked all the follow-up questions that I would now. But that was the sense. And we did share, for instance, when talking with them, that one of those people on our board in that situation is Doug Baker's the CEO of Ecolab, which is headquartered in St. Paul. He's on our board just down the street, and then a couple blocks farther, he sits on Target's board. So that would be a situation where if locations, we're all with it, that's all local calls, it's all right here. And they did seem to be interested in that. Now, I don't know what we would say. I mean, in our bio, he's lead director of Target, also on Michelet Mall. I mean, I don't know that we would do anything.
He can walk from one company to another.
Right. In terms of attendance, also, we certainly said, well, we want to see more than just, no one tripped the 75% rule that's in SK. And we already are in the habit of doing, our average attendance, and it's always in the high 90s. I don't know if you would break it down. By the way, our overboarded directors are super good. But so it's just thoughts, I guess. If you're not doing the average attendance or you're not doing whatever, maybe you could take that step, and that might help above. They did say that 75% is not great information for them in making these decisions.
Yeah, we do the same in our proxy where we disclose the average attendance, and we've started disclosing. We've had a number of directors who've all been at 100%, so we'll disclose the number of directors that attend every meeting on which they serve. So, but back to your question about the location, if you have a significant number of directors in another city, do you then have to disclose if you're holding meetings, like by way of example, if you have a lot of directors in New York and you have 2 of your 4 board meetings in New York, do you then need to disclose that as part of this process? I think becomes a very slippery slope.
Yeah, it can really junk up your proxy statement trying to address a specific concern. But
And there's enough in the proxy as it is. It is interesting, though, if you may trip up the overboarding, or if you have a number of directors who are on the edge, the level of their attendance and so on, the level of their engagement could be a useful factor for not just ISS or Glass Lewis, but in fact investors as a whole, to determine, are these people essentially sort of, honorary members that flit from board to board, or are they actually active, useful members? So, but that would be an interesting factor. I do love the fact that you should describe that they're all on Nicollet more, the walking distance between them. We're only going to spend just another moment on Glass Lewis. The other issue is that there were some issues regarding governance following an IPO, and also they did modify, with respect to board evaluation refreshment, they modified their language to really emphasize that they are really not fans of tenures relying on, age or specific limits. They said, it just means that your board probably doesn't have the spine to kick someone off if they're not doing their job, and so they have to rely on a very crude method. That they modified their language to emphasize that they prefer a very robust method of assessment. So if there's a question of whether or not you should put in, if you're going to put in some additional language regarding, self-assessments, et cetera, it may be worth a sentence or two. If your board actually does a very robust self-assessment, they may as well get credit for it. If they don't, then it may be an area that you don't want to emphasize. So I'm going to turn it over to Tim. He's going to talk about posting annual reports.
Yes, there was a new CNDI issued on November 2nd. The SEC indicated in that CNDI that they will not object if companies post their annual report on their website for 1 year instead of delivering hard or electronic copies to the SEC. There has been a requirement that you file 7 hard copies, or file at NEDGAR, of your annual report with the SEC each year. This change does not affect the NYSE requirement that you file hard copies with the NYSE of your proxy materials, so keep that in mind. I am not surprised by this development. In fact, I think this is a case of the SEC catching up with what is probably a fairly common practice. Brock Romanek has indicated on his blog that there's a lot of confusion about this already, and this CNDI helped clear that up. But I have a feeling that the SEC has not been receiving all the paper annual reports it used to anyway. But they've tried to tie a bow on that. Luke, you wanted to talk about notice and access at this point.
Yeah, so I mean, I think many of you are probably familiar, if you take advantage of notice and access of internet availability, you're filing you're posting your annual report and proxy statement online as it is already. And interestingly, when we were doing an analysis of, with 4 new board members coming on out of 7 total, you can imagine we had to blow up the board calendar and start all over in terms of our meeting schedule. So we started looking at other retail companies' annual meetings, and of 14 companies we looked at, just to figure out their annual meeting date, all 14 had indicated they'd used notice of internet availability, but 6 of them had failed to file or post and file their proxy statement within the 40 days required. Now, whether the SEC has, addressed that or not, but I think that's an important thing to remember, that, if you do take advantage of notice of internet availability, there is the 40-day requirement. And we didn't investigate further to determine whether or not they actually did a full mailing if they didn't, post within the 40 days. But I just thought it was interesting that almost half hadn't met the 40-day requirement. So
It's a good point to remember. We go now to Kim for universal ballots.
All right, I think I'm going to spend about 10 seconds on this, given the recent election. The SEC proposed some rules regarding the mandating the use of a universal proxy, particularly with contested elections. Essentially, the whole point of this is the SEC has long wanted to make the experience for someone who's voting by proxy to have the same rights and access to be able to split their votes between ballots, which currently you can only do, absent a universal ballot, if you actually physically attend the meeting. And so the SEC is very focused on the idea of allowing a shareholder the ability to behave in the same manner, but not actually have to show up at the meeting, because most people vote by proxy. The Republicans are against this. The Democrats are for it. There's currently 3 people on the commission. I do not see this going anywhere. It was on a wish list for the it was on a wish list for the Democrats. Highly controversial. You can ignore this. I think it will never happen. All right. However, something you actually shouldn't ignore, because this actually goes to every single proxy, and it's one of those sort of weird, picky little points that nobody actually ever reads, but frequently turns out to be wrong, and it's something the SEC is focusing more and more on. It's the applicable vote standards that you put into your proxy statement. So, the CII has commented that they wanted rulemaking. The SEC has actually, when they put forward the universal ballots, which won't go anywhere as we recall, they also put forward amendments to the form of proxy relating to any election of directors. And I would be very, I would not surprise me at all if this occurred, because this is actually, it's very non-controversial, but it is something you should pay attention to, even though it's currently simply a proposal. These are things that you would have to put in an against voting option on election of directors, for example, particularly if you're using a majority vote standard. So it's sort of a reminder that, if someone's withhold or against vote actually has a legal impact, you should be giving them an option. You also want the ability shareholders to abstain, proper and good disclosure requirements relating to all voting options and all voting standards. I know this seems tedious, just bear with me. I won't spend enormous amounts of time on this. So on the next page, what we did is just a quick reminder of the different primary voting standards that are in place. We won't go through them here, just some recommendations for you. Don't forget to include the impact of broker non-votes, abstention, and withheld votes. I understand that when you have different kinds of votes, this kind of disclosure can get kind of messy, particularly if you have a number of proposals with different voting standards. A useful reference, you can take a look at the Intel Corporation, their last proxy statement. They had a very useful chart that went through it that outlined it very, very cleanly. It cut back on a lot of the text, and it was very accessible. So particularly if you have a number of things on your agenda, it might be useful to go to a chart format. I'm a huge, huge believer in charts and graphs. And then one point is the concept of routine versus non-routine. There aren't that many routine matters anymore. On most proxy statements anymore, the only routine matter is going to be the ratification of the appointment of auditor. But, there are some things like if you're putting a reverse stock split in front of your if you're going to put that in front of your shareholders, that would very likely be a routine matter. But Helpful hint from Cam, because this is how she used to do it. If you have any questions about whether something's routine or non-routine, what did you do?
Just email your set of proposals to the stock exchange and say, hey, can you clear what I've said on the voting standards? It's something I would do every year.
Yeah. So, they'll get back to you and they'll tell you, because I know, in a couple of instances when we've done that, they said, well, sometimes we recommend this versus this, particularly when it gets more into governance issues. So on those types of things, go talk to them. You pay them fees anyway. You may as well access them. And so they can give that to you. And so then you can more accurately describe the impact of a broker non-vote or whether there'll be broker non-votes at all. I'm going to turn it over to Cam to discuss auditor disclosure and independence.
Thanks, Kimberly. So everyone, as you're preparing your audit committee reports this year, just remember to replace auditing standard number 16 with auditing standard number 1301. That's communications with audit committees, and it was just reorganized. There's been discussion about a move towards more mandatory disclosure on audit committee or auditor independence, et cetera. I think it's safe to say at this point that that's not coming. But notwithstanding that, there has been a recent trend towards more voluntary disclosure, especially among larger public companies. So for example, 50% of the Fortune 100 disclosed factors considered by their audit committee when assessing auditor qualifications and work quality last year. And there will continue to be shareholder proposals on this topic. For the 5th year in a row, the Carpenters Union will be submitting proposals, sending letters asking for enhanced auditor independence disclosure. And so I'd like to turn now to you, Alyn, and ask you, how does your company think about auditor disclosure issues?
Yeah, so this got kicked off for us in 2011 when the Carpenters first kind of started their campaign, and they did write to U.S. Bancorp and was looking for some more disclosure, and so we complied with that. And then since then, we take a proactive approach that every year we look at this E&Y report that's on your slides, Cam. We also look at this year, at least, we looked at one for the Center for Audit Quality, so that we use those to kind of benchmark and look. And the idea is not that we have to say everything that's majority and we don't say anything that's not majority, but just try to see, I think our general goal is to kind of keep up with what's being said among the large public companies. So we try to see what's going on, what makes sense for us in terms of, what our minutes reflect, our charters, our comp committee policies. And we'll also look at our peers as another kind of source to triangulate, and we'll kind of tweak and adjust each year, and then work with the controllers group, and then obviously ultimately the audit committee and the auditor.
Yeah, thanks, Alyn. Luke, how does that sound, or how does that resonate with your experience?
Ours is different. I mean, as a smaller company, we are not as proactive in trying to deal with the voluntary disclosures. We have not included any of them. We have, knock on wood, not heard from the Carpenters Union, so please keep that quiet.
Maybe you shouldn't have said that out loud.
Yeah, probably not. But we will look at it again this year. We work closely with our auditors in actually preparing the report, but we've not traditionally, done more than what is the typical response or typical report.
Thank you. So turning briefly from disclosure over to enforcement, a couple of enforcement actions that are good for auditors to keep in mind for their own internal monitoring purposes, but also for audit committees in their oversight of auditor independence to pay attention to. The SEC brought enforcement actions in two separate situations against E&Y, where there were personal relationships between auditor representatives and people at the client that ultimately were deemed inappropriate and led to significant penalties, as well as the individuals involved at E&Y being suspended from practicing as accountants before the SEC for at least 3 years. So this is something that I think we as counselors to audit committees should keep in mind as they're reviewing auditor independence in the coming year. Tim, what do we need to know about SEC disclosure effectiveness?
The SEC Disclosure Effectiveness Initiative was kicked off by the Jobs Act and carried on by the FAST Act in 2015. Looking at the more recent developments, springing from the FAST Act, the SEC put out a concept release in April of 2016. And I might mention the FAST Act set up a number of report requirements for the SEC and a number of short deadlines for proposing rules coming out of those reports and studies. And so the SEC has been pursuing that process, starting with the concept release in April of 2016 on disclosure reform, followed shortly by 3 proposing releases in June, July, and August, proposing changes in the property disclosure requirements for mining registrants, to eliminate some duplicative requirements in SK and SX, and requiring hyperlinking of exhibits under SK. The most recently, there's been in November 2016, so just last month, the SEC put out a study with multiple recommendations on additional disclosure changes that could be made. All of these things are being driven by the FAST Act and the short deadlines built into that act. I'm not going to go through the list of things that have been proposed here. There's a lot of, I think, good stuff being discussed. I mean, obviously, the disclosure can be improved and modernized. None of it is groundbreaking or radical, and I'm going to let you read the detail. But the other thing to remember is none of it is implemented yet. It's all in proposal form, and we will see where it goes. I think we go to Cam now to talk about Trump and the SEC.
Yeah. And believe it or not, I'm not spending a lot of time here. I think what we do know is that for a period, there are going to be 2 commissioners who are active on the SEC commission. But as Brock pointed out in his blog, believe it or not, this is a quorum, but we're not expecting rulemaking to happen anytime soon in 2017. And then when it does happen, I mean, what's going to be the nature? You know, there's been a lot of speculation that, initially at least, the transition team will be focused on Dodd-Frank regulations with regard to the financial services industry. And so some of the issues that we as, members of the corporate secretary's team might be interested in, like, say, on pay or CEO pay ratio, may not necessarily get, top seat. But nevertheless, if we were to look at the Financial Choice Act that Jeb Hensarling out of Texas has proposed, I mean, there may be some clues there as to the direction of the Trump administration with regard to some of these issues. And so I'll leave it there. I think one question that a lot of us have on our minds is, well, there are these, pretty onerous requirements to start preparing for CEO pay ratio. So where do we go from here? And I'm going to turn that over to Kimberley to discuss with our guest panelists.
Yeah, so, it was interesting, a couple of days after the election, I ran into, and I was chatting with a corporate secretary at a major company, and she said, well, look on the bright side, maybe we can finally kill CEO pay ratio. She said, maybe we won't actually have to do it. But that may, ultimately, we can all hope, go away. But in the meantime, it's still around. As a reminder, most companies are going to be required to disclose CEO pay ratio next year for this fiscal year. And it is our strong recommendation that no matter how silly you think the rule is and how confident you are that this is going to go away, that you treat this as if you are going to have to disclose it next year, and that you don't sort of shelve this in the hopes that, the SEC will finally come to its senses and get rid of this rule. So that is my hope as well, but I don't think we should assume that. So I'm not going to go through all of the disclosure requirements. I think we've all read them probably multiple times. But one thing I did want to go to is, Alyn, what has been the status of your company's preparation? How has that gone? Are you stopping, starting?
Not stopping, no, we'll put our pencils down if and when, as you advise, and that's definitely our plan, if and when, things actually change. But no, it has begun, and I was talking to our comp people about this last week, and he said that they kind of got a great gift, although they didn't recognize it as a gift initially, in that our COO asked them about a month ago for a back-of-the-envelope number. And they had planned on doing the dry run, as everyone's telling, and of course that sounds like a great idea, and I don't think it never got to the top of their to-do list until, it came from the chief operating officer. So it forced them into doing a dry run, but I think the message was, he said it was so great, it was so valuable, and they were so glad that they were kind of pushed into doing that now instead of waiting. And what it really highlighted for them was some methodology questions that they didn't anticipate until they were actually all the way into it. They were able to set them aside because they could give just a range to the COO, and so that's fine. But for doing the actual number, for the big one, and it would be different for every company, For us, it was the rolling 12-month period that can be selected to identify the median. In our company, our business line incentive plans pay out at different points, so that was the particular challenge that they identified, but they didn't realize it was as bad as it was until they're actually in the weeds. So I think the message is, yes, the dry run's a great idea. They learned a lot from that. They're setting it aside now. Got year-end proxy statement in the spring, going to turn back, resolve the methodology questions. We still do have on our to-do list, but kind of after that, messaging internal and external about the size of the ratio, and also just the identifying from an HR perspective what a median employee is paid at US Bancorp. So that's on the list too, but that one will wait.
So for you, is it the concern on the messaging, less a matter of what the actual ratio is, but it's more of an internal concern of figuring out what that median is, and so all of a sudden half of your employees are going to know where they stand?
Yeah, I think so. I mean, you talk to different people, and different people have different concerns, but I think there's more concern on that, and the ratios, of course, are going to be kind of crazy and all over the map. I think the apples to apples, you take. Some of our peers are kind of money center banks. We're kind of a really large Main Street bank. And so, our median employees probably paid less than the median employee at like JP Morgan, as an example. And, how much messaging do you do around that? Do you do that? Yes. So kind of all of it. But I think the employee piece, because I think the general sense is that people aren't expecting to get much information from the ratio.
Right.
And obviously, the top line number is available. Whether or not people pay attention to it, it's out there. That's not new.
Right. Any concerns for you, Luke?
Similar to what Alyn said, I think in our case, 75 to 80% of our employees are part-time. So the median as compared to a full-time CEO is going to be pretty significant. And we're still in the very early stages, so we don't know what precisely it's going to look like. But I think given that, the issue of how it's communicated internally is going to be more important, I think, frankly, than how it's communicated through the proxy statement itself. So.
Yeah, I think it's safe to say the rules provide companies with significant flexibility in determining their methodology, for example, what compensation measure to use. So companies are experimenting with methodologies and seeing, well, what does that final number look like, at least on the back of a napkin. Mm-hmm. Yeah. Okay.
So we can move along. I'm going to turn this over to Tim, who's going to be discussing virtual and hybrid annual meetings.
All right. The next topic is virtual and hybrid annual meetings. This is, I think, one of the leading edge considerations facing issuers today is what kind of meeting to hold. You can hold a traditional meeting in a room like this. Many public company annual meetings are held in this room. You can hold a virtual meeting, an entirely electronic virtual meeting, or you can do a hybrid, which is a combination of having a physical location and virtual participation in the meeting. The number of virtual-only meetings has increased from about 27 in 2012 to 136 this year. The advantages of a virtual meeting, there are a number of them. They may improve shareholder access just because it's easier to connect to a virtual meeting than to actually travel to a physical location. They can reduce time and cost spent on annual meetings, don't have to hire a hall or whatever. And there's increased board or management control over the Q&A. The questions are submitted outside of the vision of the shareholders, so there's more control on what gets answered. There are cons to a virtual meeting, obviously. It may reduce the effectiveness of shareholder engagement. There isn't the seeing you in the flesh effect of meeting the board and the CEO. It also may allow too much control over Q&A and may undermine the legitimacy of the Q&A process. There's an increased uncertainty in voting because the voting happens electronically and it can change. Things can happen electronically during the meeting that you don't know about until the meeting is in process. And it may require that shareholder lists be made available online in some cases. Interestingly, the institutional shareholders, CalPERS, CalSTRS, and others, they support hybrid meetings, but they are not in support of strictly virtual meetings. ISS on the ISS on the other hand may make a negative vote recommendation if a virtual meeting is used to impede shareholder discussion. Obviously, a very subjective standard. Virtually all annual meetings are governed by, virtual and hybrid annual meetings are governed by state law, by the state law of the state in which the issuer is incorporated. There are 22 states that have permit virtual meetings. That includes Delaware and Minnesota. Some states, though, have allowed virtual meetings but imposed conditions which are not, you cannot reach. For instance, California requires that there be unrevoked shareholder consent to hold the virtual meeting. So you could have your meeting yanked out from under you if one shareholder revoked his consent on the eve of the meeting. 17 states and the District of Columbia do not permit virtual meetings, but do permit hybrid meetings. There are 11 states that require a physical meeting, but they let people permit people to participate remotely. The SEC and the stock exchanges have not weighed in on this. This is really a matter of state law. Under the Delaware and Minnesota statutes, the requirements to hold a virtual meeting, one of the main ones is you have to implement reasonable measures to confirm that each person voting is a shareholder or proxy holder, and to provide them with an opportunity to participate in the vote. You also have to maintain, obviously, a record of votes made and other actions. Companies have to obviously comply with other statutory requirements that are applicable to any meeting, such as notice and provision of shareholder records, et cetera, et cetera. This is a very interesting topic, and we are lucky today because we have someone on our panel who has personal experience with not just traditional, but hybrid and virtual meetings.
And has opinions on them.
And has opinions. Luke, if you could tell us about your history, experience with all three of these things.
So 4 or 5 years ago, we had an annual meeting, and we do conduct our annual meetings here at Dorsey, unless they're virtual. We had no shareholders show up at a meeting, so it was over in 7 minutes.
That's the perfect annual meeting.
Well, I would, no argument there. So we then did, in 2014, we did a virtual meeting. And in 2015, we did a hybrid meeting here. And then last year, we returned to doing a live-only meeting. Our transfer agent, is active in pushing or promoting, I should say, the virtual meeting, and it does have some advantages. I think a very significant advantage is it allows your directors to participate remotely. So it does give you the benefit if you're trying to disengage, for lack of a better term, your annual meeting, from your board meeting schedule, which for a company like us can be an important consideration. It allows you to do that because you obviously want your board members to attend the meeting, but it is, in our case, flying them in from all parts of the country for a 10 to 15 minute meeting in and of itself is not very productive. So, the virtual meeting allowed us to do that, and they were all present. When we did the hybrid, it was a bit more of a technological challenge, and I think that I suspect our transfer agent has worked to improve that. But in order to we didn't just encounter too many issues in making sure it was going to go smoothly, in both having everybody in this room available to hear and see things, and then be able to do it remotely, such that last year we went back to just doing it live. The challenge there, as I mentioned earlier, we had 6 members not standing for re-election, and had we done a hybrid, they would have likely potentially participated, but they did not attend the meeting, so that'll create an interesting disclosure in next year's proxy. So, but it does offer that advantage. What Tim said is it does allow more shareholders to participate, and so they can ask questions remotely, and for that reason, I'm sure many of you already have the practices. It's very important to have rules of conduct for the meeting that outlines the types of questions that are appropriate and those that will be the subject matter of which will be considered inappropriate, and you don't need to even address if you feel they're outside of the rules. So, but it definitely does offer some advantage, and I do think it's probably something we'll revisit again in the future. But it was a real challenge, and we just weren't comfortable last year to go through that exercise, particularly given all the other issues we were dealing with the turnover in the board.
So Luke, looking forward, you've done a live, a hybrid, and a virtual. Well, what do you think you're going to do next year?
I think we haven't decided, but I suspect it'll be certainly live, and whether it'll be a hybrid in addition to that, I don't know. So, but okay. I'm confident I don't think we'll go back to virtual, at least for the moment. So.
All right, very interesting. I think now we go to Kimberley and developing some shareholder proposals.
All right. I'll try to briefly hit the high points here. And so there have been some developments in shareholder proposals. So if you've ever gone through and tried to figure out, done the 500 word count, website address counts as one word. So you can't go and actually just assume that all the things on their website actually count to that limit. It doesn't. You could exclude the website if there is, if it's considered to have false or misleading information. Graphics, can they include graphics? Does it count to the limit? Yes, they can include graphics. No, it doesn't count to the limit. However, they will also still look at it a case-by-case basis, again, going to the false and misleading standard. So, as proxy statements, are more graphically and visually oriented, we're expecting that shareholder proposals will move in that direction as well. So, unfortunately, you can't count, everything to your 500-word limit. One thing that I do want to spend a moment on, just because I've had this experience with some of the clients I work with, is descriptions on proxy cards. Yes, I know you're thinking, man, this is tedious. She's back on proxy cards. So, but yes, I am back on proxy cards. You need to make sure that your description is both clear and impartial. It's at one point, it was several years ago, a client asked me, because they were really, really annoyed with the shareholder proposal. They said, can't we just list shareholder proposal? And no, we didn't allow them to just say shareholder proposal. But there is, depending on who your proponent is, there is sometimes the desire to kind of put a little short shrift there, or to, phrase it in a way that you would prefer. You really can't do that. You need to be, and this also goes for your own proposals. If it's going to be a proposal to do, to increase your size of your authorized, or increase the size of your authorized capital, you can't say proposal to amend our articles. It can be proposal to amend our articles to increase the size of our authorized capital. It has to be clear. It does have to be, it does actually have to describe the basic purpose of the amendment. So, when you're going through, do take a look at it, not just on the voting options, but also on the description, to make sure that it's clear, and make sure that someone, when they're looking at it, understands what that proposal is, so they don't need to go back and actually reference your proxy to figure out what they're voting on. So that's my soapbox on proxy cards. So in the interest of time, the Business Roundtable proposal they put out because they wanted to amend the shareholder proposal process. The details are in here. I think we're going to move past that. Because I think, all of us, when we had discussed it earlier, you can look at the proposals. I think most of us felt the current system works pretty well. I'm not sure that it actually needs much change, except sometimes with respect to the criteria that the SEC would use for either, the ordinary business exception or otherwise, when we're looking at some of the subjective criteria. Sometimes, a clearer framework from the SEC may be useful, but I think that also would mean that shareholder proponents would be able to go to that same framework and design their proposals to be able to get past it. So that cuts both ways. Let's see. So I think I'm just going to go to proxy access. The proxy access, the thing that will never die. I think it is with us. It continues to be one of our dominant corporate governance proposals. The average votes in favor continue to increase. Interestingly enough, there were fewer that passed in 2016 than 15. But now that we've gotten past the first wave was the proposals to get them adopted. We're now in the second wave. This is the fix-it proposals. This is proxy access light. So you already have a proposal. You've drafted it. It's pretty, it's perfect, and you're like, okay, I'm done. Well, you're not done, because now they're going to come back and say, well, we want you to fix these things around the edges because these are the things that we care about. So we want to either change the number of directors from 20 to 25%, or we want to modify the ownership thresholds, or, whether or not things can be lent out, our lending, our shares that are lended out to those count, et cetera. So amending proposals actually seem to be getting through on a pretty regular basis. So if it's a proposal that comes out and said, here, we want you to fix X, Y, and Z in your current proxy proposal, unless it's something, unless there's a major change that you can accommodate, it's probably something the SEC is going to let through. For example, let me tell you in a situation where you can, you might be able to get this thing kicked if you fix your proposal. If you're a company that currently has a 5% threshold, not very common, most companies don't go to 5%. If you are someone who has a 5%, you get a shareholder proposal that says, we want you to do X, Y, and Z, and X is reduced from 5 to 3. If you reduce from 5 to 3, but you don't do the other things, there's a decent argument that you have substantially implemented the material provisions of what they wanted, and you might be able to get it kicked. But for most companies that currently have probably sort of the standard, 3%, the 2020, which is sort of what most people have, I don't know that you can count on being able to exclude the fix-it proposal. We have not seen that as the trend from the SEC. So I think, let's see. Well, let me actually, because in the interest of time, we've got a lot of other things. Let me go to our panelists. In terms of proxy access, either the fix-it proposals or things that your board is considering, Alyn, what are you currently thinking about? Is there a concern here on proxy access? What is the corporate secretary's office? How are you guys viewing any concerns about challenges on proxy access?
Sure. So we got the New York City Comptroller proposal last year. And at that point, the 3/3/2020 was a pretty clear path for us, so we didn't really worry too much about the main terms. We do have the minimum of 2 directors with the 20%, so we did that. But so our thinking really was on the ancillary terms. Before engaging with the proponent, we did engage with our major shareholders, and that was, I think, very helpful. And then we just, I think, really thought long and hard about what we actually cared about. The goal was, we know we couldn't really do anything to avoid a 2.0, but we wanted to put ourselves last on the list. So we actually ended up adopting ancillary terms that were more shareholder friendly than would have been necessary if the goal had really just been to get rid of the NYC proposal. We weren't really worried about NYC. We were kind of looking past them. What can we do to try to go through this process as few times as possible? So a lot of the things that are on the list of the 2.0 or that are on CII or ISS's list of undesirable things, we didn't have in the first place. Right. So that was, and so at this point, I think we, just like anyone else, we're waiting and seeing, but we don't feel that we have particular vulnerabilities that we right now are trying to forecast or get ahead of. If something comes, we'll deal with it then.
Luke, did you want to make any comments about proxy access, or is this not something that keeps you up at night?
Doesn't keep me up at night yet, so.
All right. Fair point. I think there's a lot more information in the slides. Given our time, I think we're going to move forward to proxy priorities for 2017. So I'm going to be turning this one over to Kim.
Yeah. So, given the landscape, both, larger in terms of the election and then also the developments in proxy disclosure practices over the past year, I'm curious to know what your priorities are for your proxy disclosure in 2017. And so let's start with Alyn.
Sure. Well, this year is actually a pretty quiet one. I mean, as you can tell from the presentation today, not a lot in terms of new rules coming down the pike, and we don't have a lot on our ballot this year. That's really particularly concerning or taking up a lot of time. So our focus is really on what are our shareholders talking about, and what do we hear over and over in our shareholder engagement that we did in the fall. And the 3 particular kind of smaller pieces that I've picked up on that I want to enhance both in terms of the content and how we present the information graphically is board evaluations, nominee skills and qualifications, and then director tenure. Those are areas that I think that we can move the ball forward, so I'm kind of focused on those. Slightly bigger picture, I'm looking to refresh the proxy summary. Last year we did kind of a general facelift of the graphic appearance, the look and feel of the proxy statement, and really focused on the CD&A. I think the proxy summary is something that's easy to kind of, a stone you can kind of kick down the road. And it's not that it's out of date, it's all still accurate, but might not be telling the most compelling story anymore. So taking this opportunity this year to really do a deep dive on that. Some of the things that I mentioned, of course, are proxy summary items, in terms of nominee skills and qualifications, director tenure, going to look to bake those into the summary. I'm working really hard on revising our governance message, and then I'm collaborating with, and I think this is one of the reasons maybe it doesn't get revised as often, because it involves more cross-company collaboration, the summary in some ways, but I'm meeting tomorrow with the top folks in IR and corporate communications and executive comp to really make sure that that message, the corporate performance message, and how that ties into the exec comp message is really coherent and is matching up with our other, internal and mostly external, but also internal messages, about those pieces and what's important to U.S. Bancorp going forward. So that's what my focus is.
Yeah, sounds like you're really spending resources to know your audience and fashioning your disclosure accordingly.
Yep, that's the idea. And incremental, like I said, we did a lot last year on the look and feel and did a lot in the CD&A, and this year kind of tackling, you don't have to do it all in 1 year, just try to always kind of chip away.
Yeah, baby steps.
That's right.
Yeah, how about you, Luke?
Similar, we're always looking to try to improve it, and we recently switched to a new web-based filing platform that I think will give us a little more flexibility. So, with increasing focus on the use of graphics, we'll continue to try to do that. One thing we talked about as a panel is, I've been seeing more and more proxies with the Q's and A's in the back rather than in the front. So I suspect we'll probably switch that. We have, I mentioned, the change in the board. So we have 3 of the 4 compensation committee members are new to the company. So they joined the company mid-fiscal year. So, obviously getting their input on, the compensation philosophy description is going to be critical. And, there theoretically could be some significant, rewrites with respect to that. So I think those are the key areas of focus. So we're always trying to improve the look and feel and also shorten it. So, despite our best efforts, it seems to get longer and longer, so.
Now you have to talk about where all their boards are, everything.
Yeah, well, that's great. So, it's paying attention to shareholders, and it's also paying attention to how your board is composed and how their philosophies on compensation and governance matters may change.
One point we had, and my apologies for interrupting, Cam, with one of our clients, they decided to, for the first time in years, they decided to do a radical rewrite of their equity plans. And these guys have always had a very, very strongly held belief in their compensation structures. And as their board changes, that changed too. And so they're doing a significant new approach in terms of their equity plans, how they want to describe their CD&A, et cetera. And what they've had to do is revisit their corporate calendar significantly and bringing in the, a lot more meetings with the comp committee, pushing everything up. And so it completely reorganized their corporate calendar far sooner, I think, than they had even anticipated, because the compensation committee wanted to be, much more deeply involved earlier. So I think whenever there's something that's anticipated, the first person I guess you need to call is the chair of the comp committee and figure out where everybody is and, when they're going to be available, because it threw off their schedules even after they started working on their calendar once they started looking at everybody's holiday schedules.
Yeah, no, very good to keep in mind. And, my last point here is more of a technical one. The amount of scrutiny that GAAP versus non-GAAP received with your 10K reports, or will receive, the same type of scrutiny may apply to your proxy disclosure on performance results. And so we'll need to keep that in mind, in particular, if the financial results you disclose in your 10K and earnings results, for some reason the adjustments look a little bit different than what you're disclosing in your proxy statement for compensation purposes. And on that note, I'd like to turn to Tim for our final slide, which is a very important reminder about where the SEC comments are coming in on non-GAAP disclosure.
Yeah, this is just a warning that the SEC did update their C&DIs on non-GAAP disclosure, and it has now become a new focus, or once again a focus for the SEC. There's a Dorsey memo on point if you want to know the details of the C&DIs that were put out. But the key for you to know is that there is this new focus on non-GAAP disclosure. There have been to date about 150 comment letters delivered that have given comments on non-GAAP provisions. Some of the most common comments are on this slide. I think the first one is one I have seen repeatedly, that you need to give equal or greater prominence to the directly comparable GAAP financial measure. I remember that from the adopting release. That was the case early on, and I told clients that, and they did it. But in intervening years, it's been harder and harder to get encourage compliance with the non-GAAP rules because they can look around and see all these non-compliant competitors. Well, that is changing. The SEC is providing these comments, and enforcement will not be long behind. So keep in mind in your 10K this year and in your earnings releases, et cetera, that you need to pay special attention to non-GAAP measures and how they're presented. You may want to go back and look at these C&DIs to make sure you're in compliance. That's all I had to say there. And
Okay. Well, we're at the end of our time. Thank you so much. We're going to be sending out emails with a couple of updates on D&O questionnaires that may be helpful for you in your process, as well as links to relevant memos. Go forth and draft, and happy holidays.